Hello and welcome back to our podcast, People Acting Like Lawyers and Mostly Malarkey on Listen Frederick. I'm your co-host Meg, and with me is my co-host Dee, better known as Devin.
Hello again, everybody.
Devin and I are both Maryland lawyers. Devin's an immigration attorney. This podcast episode in no way constitutes legal advice, which can only be obtained by a licensed attorney in the context of a private and confidential legal consultation. We disclaim any and all liability for what our listeners may or may not do in their own lives based upon our dialogue on this podcast, which is strictly for entertainment purposes only.
And remember, everybody, please drink responsibly.
Today's episode is the scope of liberty, and our subtopics today may include Supreme Court Justice John Harlan's definition of the scope of liberty, Supreme Court Justice Douglas's opinion in the Griswold case and the Penumbra Doctrine, liberty rights that are deeply rooted in our nation's history and tradition, and various freedoms to include, but not limited to, the freedom from bodily restraint, freedom of speech, and common law privileges such as the pursuit of happiness. To kick off our episode today, we're starting with a toast of recess. So Devin, you want to tell us about?
Yeah, there's a big hype about non-alcoholic beverages. Today I have recess, sort of a mood drink. It has adaptogens, magnesium.
I have strawberry rose. Cheers.
Cheers. I think you agree that it is delicious.
I really like it.
They're all great. Yeah, recess they're amazing.
Well, they have the lime too.
The lime is great.
So Devin, what are the two most essential liberties for all Americans, in your opinion?
Two most essential liberties. In my own opinion, we're not talking about any legal doctrines. I think the right to make money and the right to have property are the most important liberties. And this is in the context of the times that we live in. So today, that's what I think the two most important aspects of liberty are.
Okay, well for me, I would have to say the freedom from bodily restraint to include, up to and including incarceration. And then I would have to say freedom of speech, even though I typically think of freedom of speech as a fundamental right because of the First Amendment and the case law saying that it's a fundamental right. It's also a freedom, so I think of that as an essential liberty and freedom in this country.
I think you talking about bodily autonomy, the freedom from being detained and having freedom within the ability to move your own body, that's essential to even make money to get property. I think we're both on the same page there.
When I think of freedom from bodily restraint, I also think of the protection against cruel and unusual punishment, right, in the Eighth Amendment, because it used to be they would beat confessions out of people or they would torture people to get them to say something, and people would, a couple hundred years ago, they would say just anything just to not be tortured. So Supreme Court Justice John Harlan II's dissent in the Poe v. Ullman case, this is a 1961 case, his dissent reads, "The scope of liberty is a rational continuum, which includes freedom from all substantial arbitrary impositions and purposeless restraints." So this is with regard to government action. And so liberty rights safeguard the right of the people from government overreach, ensuring we can exercise our freedoms and our autonomy in the pursuit of happiness, education, and our occupations, which I think you were touching on. Occupation of your choice.
Yeah, the ability to make money. Yes. Is this the Penumbra Doctrine, Laura?
No, that's the Griswold case. So we're getting there.
Okay.
We'll get there. I like Harlan's definition of the scope of liberty because he's not defining the word liberty and saying the word liberty in the American Constitution means this with one sentence, right? He's saying liberty, and I think you have touched on this before, liberty is a fluid term, right? But he refers to the scope of liberty. So he's saying the scope of liberty, it's a rational continuum. You should be able to rationally conceptualize what that is.
And when we say rational continuum, I guess another way to say that is
fluid.
It changes. It's fluid. It could change. We're witnessing that today. An overturning in certain states and the right to have abortion. You're seeing the rational continuum take place today with topics that are in the news as we speak.
So full disclosure, I'm an adjunct professor at the local colleges here in Frederick, where I have taught since summer of 2015. So I do have my lecture notes in front of me. But with regard to liberty rights that are inherent in the Due Process Clause of the Fifth Amendment and other amendments, with regard to, of course, the 14th Amendment talks about state action, okay? But liberty rights inherent in this notion of due process, freedom from bodily restraint, the right to contract, the right to engage in a occupation of your choice, marry the person of your choice, acquire useful knowledge and education, establish a home and raise children, worship God, and the common law privilege, the pursuit of happiness. When I was in constitutional law class in law school, we learned that, of course, under the Ninth Amendment, that the Bill of Rights is non-exclusive, right? So you had the Constitution that was ratified in June of 1788, and then the Bill of Rights was drafted in 1789, and it was ratified in 1791. And when we say the Bill of Rights, that's the first 10 amendments to the U.S. Constitution collectively.
Correct.
So why didn't the framers include the Bill of Rights in the Constitution initially? It's because they believed that guarantees of individual rights and freedom wouldn't come necessarily from rights that had to be spelled out and you had to go to court to judicially enforce them. The protections for individual rights and liberties would come from the structure of the U.S. government itself, because you have the different branches of the government. So you have the legislative, you have the judicial, and you have the executive branch. And so the idea was, if you have this separation of powers and you don't have too much power in too few hands, then that is the greatest protection of the people, not rights that they have to say, well, I have this right, and you're trying to take it away from me, state of Maryland, so now I have to go into court to enforce this right. It was like, let's set up the government in a way that protects individual rights to start with. But in any event, you did have, of course, the Bill of Rights passed not long thereafter, the Articles of the Constitution.
But liberty to me, it's kind of a frustrating term because it's one of these universal subjective terms. Liberty to me can mean something completely different to somebody I run into tomorrow or right after this episode. And to be honest, it's rather frustrating. It's almost like justice. Justice. To me, I think justice is a formal way of saying revenge, right? What does liberty mean? Because liberty could mean different things. It's fluid, you know.
But you did do some research, though, so didn't you have a definition that you liked?
There's a definition I like, and none of these definitions prevail. None of these definitions seize the day, and that's what is frustrating about it. I used to live. West Virginia defines liberty as encompassing freedom from servitude, imprisonment, or restraint, as well as the right to use one's faculties in lawful ways and pursue lawful trades. So to me, that encapsulates all of the individual rights that are very important within what we've been talking about in regards to liberty. Freedom from servitude, your bodily autonomy. Freedom from imprisonment, any restraint of your bodily ability to do things that you want to do. Also, the right to use one's faculties in lawful ways. To use my mind to pursue a trade, to get money, to have a career, to obtain property in lawful ways. And in lawful ways to me is within society's constraints on what liberty should be, within the fluid restraints of liberty.
Read that quote one more time.
The Supreme Court of Appeals of West Virginia defined liberty as encompassing freedom from servitude, imprisonment, or restraint, as well as the right to use one's faculties in lawful ways and pursue lawful trades. And the citation, that's Lawrence v. Barlow, 77 West VA 289 from 1915.
Obergefell v. Hodges, that was the Supreme Court case where there were laws that were challenged. It was said that these state laws burdened the liberty of same-sex couples and abridged central precepts of equality. So on grounds of the 14th Amendment's Due Process Clause and the Equal Protection Clause, the Supreme Court ruled that same-sex couples do have the right to marry, and basically the court said all states have to issue same-sex marriage licenses, when before it was a liberty right, it was a fundamental right as far as just to choose who to marry. Obergefell v. Hodges extended that to same-sex couples, right? And so in that case, you had a new liberty right that was asserted, and they won. You have a test for asserting a new fundamental right. And so what you have to go through is this analysis. You have to say, is it a liberty that's implicit in the concept of order and liberty? And is it a liberty that's deeply rooted in our nation's history and tradition? And if so, then provide a careful description of the asserted fundamental liberty to argue that the court should recognize it. And so in this case, the couples were arguing that they have a right to same-sex marriage and to have that marriage be recognized as legal in every state in the U.S.
Well, I do want to say I've got some information that that case might be overturned soon. Now, the logic behind overturning the Supreme Court recently, in decisions, hasn't really been following a lot of these doctrines too, which is concerning to me. It seems like they've sort of been making up their own lately in their most recent decisions. I don't know, do you have an opinion on that?
I would say I was surprised when the court came down with Bergefell v. Hodges, but I don't necessarily think that means all of a sudden that the Supreme Court's going to backtrack on it.
I think that it's coming. Look at the abortion
Ear
case.
to the ground, Devin.
Ear to the ground. Say, okay? It's coming soon. But let's jump to abortion. The court reversed there. And that was a liberty. This goes to fluidity, right?
You think of it as a pendulum. The pendulum swings this way.
And it swings the other way.
That way.
Absolutely correct. The original decision in that abortion case that the Supreme Court had that was overturned, Roe v. Wade, it was rooted in privacy, right? That somehow the right was derived from your right to privacy. The case that overturned Roe v. Wade, the Supreme Court basically said, listen, you don't have an explicit right to that.
However, you have the Ninth Amendment, right, which says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What that means is that the Bill of Rights is non-exclusive. So just because a right is not specifically spelled out in black and white, it's not enumerated in the Constitution, doesn't mean that the people don't have other liberty rights, such as the right to travel. And you had, during COVID, being told, don't travel across state lines unless you're going to work, right? To me,
fluidity.
That's not consistent with the Constitution.
You're right.
But with regard to Douglas's opinion in the Griswold case and the Penumbra Doctrine, what the court said is that there's penumbras of privacy, and that applies to married couples, their business and their marital lives, right? There was a law that was on the books in Connecticut that was passed in 1879. And in the 1960s, you had people from Planned Parenthood, workers there that were convicted, like they had criminal convictions for counseling married couples about using contraceptives, counseling them, but also prescribing them with contraceptives. They were convicted and they appealed that to the Supreme Court, saying that the state law was unconstitutional. And of course, the Supreme Court ruled in their favor. But what the Supreme Court said in that case is that, okay, so if you look at that test for a fundamental right, is it a liberty that's implicit in the concept of order and liberty? Is it a liberty that's deeply rooted in the nation's history and tradition? So what the court said in that case is that marital privacy, what goes on between a man and a woman in their own bedroom and their own life planning to have kids or not have kids, marital privacy is older than the Bill of Rights. It's older than the Constitution, which is a good argument.
Yeah, man.
But it goes into like these privacy rights, right? What Douglas said in the majority opinion in the Griswold case was, it's not just penumbra, singular. I think of penumbra as like it's an umbrella and it casts a shadow, and anything that falls under it is protected. That's the way I think of it. The case mentions penumbra as plural and says it's formed by emanations from constitutional guarantees that breathe life and substance into the enumerated rights.
Well, let's kind of talk about the penumbra. What is a penumbra?
If you're asking about...
where's the origin of the word penumbra?
Supposedly introduced by astronomer Johannes Kepler in the early 1600s to describe shadows that occurred during eclipses. Solar or a lunar eclipse, but one celestial body is covering the other.
So like the sun is covering the moon or the moon is covering the sun? Is that the two? Okay. And a penumbra is?
To one of the Merriam-Webster definitions, a penumbra is a space of partial illumination between the perfect shadow, and that would be on all sides of an object and the full light. And this was Johannes Kepler in the early 1600s, but in legal terms, it's used as a metaphor with regard to what is covered and what is not covered, referring to the gray area.
Sometimes the shadow covers it, sometimes it doesn't. Once again, back to fluidity.
You have different ways of reasoning through something. You have logical reasoning, but then you also have deductive reasoning. What reasonable inferences can you make without leaping in logic?
As we have this conversation, I'm just thinking, this is like a developing definition for me. Is liberty not the lawful exercise of free will?
To an extent, yes. I think it has to do with your autonomy.
I think all these definitions, all this complicated, it is the lawful exercise of your free will. What is society willing to tolerate as far as your free will is concerned?
So we're exercising our freedoms and autonomy in the pursuit of happiness,
Yeah.
in the pursuit of our education, in the pursuit of the occupation of our choice, and I would also say marrying the person of our choice.
I think I want to pen an opinion. It's the lawful exercise of free will. That's that simple.
So now it's time for our mid-episode drink. Today I have brought in some beer. This is Yuzu Lemonade Radler. 3.8% alcohol. Cheers to Old Mother Brewing Company for providing this. And then what do you have?
I've got from Old Mother Brewing Company, Eurotrip, Bohemian Style Pilsner. Beautiful label. Shout out to Old Mother Brewing Company. Cheers.
Cheers.
To our Penumbras.
Was it Rihanna? Under my umbrella?
Ella. Interesting.
Hey.
Whew.
Now, how is that compared to the Amber Hank that you tried?
I like the Amber Hank better.
Okay.
I do. What is the Amber Hank? What style is that? I think that's a different style. I forget what they call it. Listeners, feel free to let us know.
Okay.
I think I'm a fan of
Well, try it.
ales, like a pale ale.
Well, try the lemon.
Okay. I'll try it.
I really like this lemon. I mean, it's very lemony, and I'm a fan
Ooh,
of
that's
lemon.
delicious.
I'm a
That's
fan of
delicious.
lime. Well, drink it.
Old Mother, I love the shits and giggles.
So the subtopics that we haven't covered yet would be getting into specific liberties. So as I said, my top two would have to be freedom of speech and freedom from bodily restraint. And the reason why that's so important in our nation's history and tradition is, according to the Supreme Court, speech involves the search for the truth and the marketplace of ideas. In the Ashcroft case, the Supreme Court said the right to think is the beginning of freedom, and speech has to be protected from government intrusion because speech is the beginning of thought. So speech by one person makes another person think, but also speech sparks debate, and of course, political speech is fully protected speech. I think that's essential for the health and the vitality of our nation, but I also think that on a personal level, freedom from bodily restraint, the right to post bail, the right to file a writ of habeas corpus, right? These things are crucial to if you're in jail, you're not enjoying your freedoms.
You're noting the essentials. When I talk about the right to earn a living and own property,
That's assuming you're not in jail.
That's correct. Like you're naming the essentials, and I'm going to sit here and assume that is correct, right? That's the underlying basis upon what I think essential liberties should be. And I hope those continue to be the underlying basis. You're absolutely right.
But just because the Supreme Court changed its tune and was more qualified about as far as abortion rights, you have certain states that have already passed laws in their constitution. Roe v. Wade was overturned on certain grounds. States are required to give their citizens at least as much constitutional protection as the U.S. Constitution, as the federal government, but states can give more.
There's two aspects in where I think fluidity becomes hypocritical. Bodily autonomy has to include, for a woman, in my opinion, the right to terminate a pregnancy. It's not my property. As far as I'm concerned, whatever's in your stomach is your property.
Well,
That's the hard truth, okay? If it's in your body, what is it? It's don't call it property. Call it your bodily autonomy, your body.
Emanations from your body.
Whatever it is, man. It's like controlling my ability to urinate or something. I don't understand how it is not bodily autonomy. My ability to ingest any natural substance on this earth, or any substance that is capitalistically provided to me. Marijuana, number one. Who is anybody to regulate what grows out of the ground? That's something, to me, your pursuit of your bodily autonomy, your ability to provide for yourself includes farming and feeding yourself. If there's a plant that grows, I just can't believe that a government can control something that is naturally growing out of the ground.
But on the other hand, there's tobacco and there's health risks associated with smoking tobacco, so they're required to put on the label, hey, this can cause cancer.
There's regulation.
Exactly.
And not legalization, and not making it illegal, right?
Okay, so you're okay with regulation.
Absolutely.
It's the criminalizing it that
absolutely.
that you take issue
because
with.
Also alcohol is fermentation. It's a natural process. Alcohol is regulated. Alcohol kills more people than marijuana. I find it difficult. This is where fluidity becomes hypocrisy to me. And that's the penumbra, isn't it? That's the penumbra. That's the moving shadow. It covers and then it doesn't cover. And And that's life.
So it's up to different judges in different states and different
Societies, different times.
Yeah.
Right? It's fluidity. And that's exactly what we're talking about. We're talking about the moving shadow.
So how soon do you think the Supreme Court is going to overturn the same-sex marriage case? And to what extent do you predict?
The way the Supreme Court has been ruling recently, it seems like it doesn't really take into account legal doctrine, or it pushes it aside. It's troubling to me. And I can't tell you what the legal basis is going to be for overturning same-sex marriage. I can't tell you that because I don't know, because as far as I'm concerned, they're inventing legal doctrine.
Well, it's interesting because when I was an undergraduate, right, at FCC, we watched a documentary on what happened in the UK. And in the UK, you had same-sex couples that wanted to get married, and they wanted their marriage officially recognized. The government came up with was a civil union. So they were not getting married as a heterosexual couple would, but they were allowed to have a civil union. So it was like this carve out for them so that they could have their union legally recognized. So then what happened was you had heterosexual couples say, well, why is it that they have that choice but we don't? So then they had to allow heterosexual couples to have a civil union, which then they felt as over time in society it eroded the traditional marriage, because now heterosexual couples could be like, oh, we don't want to like quite get married, but we'll do the civil union because they thought it was less of a...
And I don't have a problem with folks saying that we are rooted in a tradition of, I guess, sort of a Christian founding of in the Pledge of Allegiance under God, right? And
but that's a moral God, though, not a religious God.
Well, it doesn't say it. Well, let me tell you something. The Pledge of Allegiance doesn't say under a moral God. It says under God. So it's a subjective.
Well,
it's a subjective reading. It's fluidity. We go back to fluidity, right?
Okay.
And I'm okay with that. So, but I think the 14th Amendment is involved in same-sex marriage because when you get married, there are certain legal rights that are very important to people, and I can't tell you what they are at this point. I can't remember, to be honest. But a lot of the underlying issues with the restriction on same-sex marriage is the ability of, let's say, when a partner dies. And when you're married, there are certain rights, like you retain property from the other person, right? You do trust in estate. So there's certain things that happen when you get married. Certain rights are acquired when two people form a union legally. You can call it something different, but apply the same legal protections. To me, it's a 14th Amendment issue. If you don't allow same-sex marriage, you don't allow certain protections that come with a marriage.
Right.
Legally. That's my issue. I don't care what you call it. Call it a union. Call it a companionship. Call it friends. But give it the same legal protections, okay?
I think that's part of the reason why the U.S. didn't do some sort of carve-out and say, okay, same-sex couples, like, they can be legally recognized, but it's not going to be a marriage, it's going to be a civil union. Some concern in the UK was that this is eroding the traditional marriage, right, between a heterosexual couple. I just think that that's part of the reason why.
This was my own shoot-off thought, but I think you can separate it as long as it's the same legal protections. If it's not tradition, if it's not rooted in our moral God, I don't care what you think, give it the same legal protections. Is my opinion. I don't care. Like, just give it the same legal protections. I think that's the root of what people are looking for and what people respect that are continued to be protected, today.
They want equal treatment under the law.
14th Amendment, equality.
So the Equal Protection Clause, you're not going to see the equal protection language in the Fifth Amendment, which Fifth Amendment applies to the federal government. You see the language equal protection in the text of the 14th Amendment. Because of the Bowling v. Sharp case, the school segregation case in D.C., the court said it would be unthinkable that the states can't discriminate based on race, color, but the federal government can, because at that time, the federal government was running the D.C. public schools. So there's that reverse incorporation doctrine where equal protection applies to federal government action under the Fifth Amendment pursuant to the Bowling v. Sharp case.
It's so interesting. So interesting.
They said there's an equality principle that's inherent in the concept of due process.
Interesting points. It's a fascinating topic. It is.
There's other liberty rights, I think, with regard to establishing a home, raising children. So you have the Amish. Their children don't go through 12th grade because they're being taught to be adults, right? And they have their own religion.
You've got Native Americans. right? They've got their own liberties they can do what they want on their on their territories. Not what they want.
Well, they have their
but,
own
they've
courts.
got
They
their
have tribal
own
courts.
tribal courts. But Laura, let me ask you this: what future liberties do you foresee being established?
I recall being in law school and Professor Waysdorf, she was a great professor. She kind of grew up when it was a badge of honor to protest in DC. And what she said was that freedom of religion, it's like glossed over or it's minimized in our day and age, but that pendulum swings, right? I think that's an area where people are going to want and expect and put forth that we need more protections here on our freedom of religion and our freedom of exercising our religion. That's my opinion.
Interesting.
What's your opinion?
I think that we're going to see. This is wild, and this may not be within the next 5 years. I'm thinking of. I was listening to the radio today, and there was a topic on the origin of the word robot, and it comes from a play that was 100 years ago, and it was a negative term. I think of artificial intelligence. I think of robots assisting us, and do liberties eventually expand to them? We're talking future. Yeah, I mean, that's what I think of when I think of liberties in the future. Do they even apply to humans? I think it's interesting to think about.
Well, and you also have the right to contract without the government interfering in the terms of your contract, so long as the subject matter of the contract is legal.
Correct.
And that's a big one for people. It also encompasses your last will and testament, right? You can put in there what you want to put in there. You don't have to leave your stuff to your kids. You can leave it to the church or whatever nonprofit you want to. The government should honor that. As long as it was executed correctly pursuant to the state law.
Are those normally honored and respected?
Yeah, I mean, as long as it's a valid will.
Okay, yeah, that's good.
But when people are doing their will on LegalZoom or whatever else, like my neighbor did that, she paid whatever to do an online will for her mother, and
what happened?
The state of New York would not probate it
Did you
because
hear that,
they're like,
people?
it's not valid.
Did you hear that, folks? Yeah, go to LegalZoom, see what happens.
And what did you say about lawyers and AI? People were...
Lawyers just having AI write their briefs and just turning it in without checking anything. I mean, it's stupid. Is that what you were referring
Are
to?
they getting disbarred?
Oh, yes. Their licenses are coming attacked. They're getting reprimanded. And you know what? I think it's fair to... You should not take their license away. This is a new thing. People learn from mistakes. Okay? So I think that's okay. You can get a reprimand. Don't take your license away. Just don't do it again.
Because it's going to give you information that's wrong.
It will. And I have logged into Westlaw and LexisNexis, and they have their own little chat GPTs. Okay, so they're generating briefs too.
Oh.
So let's watch out now, everybody. Those are official sites lawyers go to research and actually generate documents. Let's find out the day that they get caught generating something, that's fake.
So why do you think it's so important to engage in the occupation of your choice and the government should not? Like, what about the draft, right? So if you get drafted, then you're taken away from your chosen job.
But this is the penumbra. When we're in a state of war, the shadow changes, right?
Okay.
And we've gotten into this argument about what powers the government has during war, right? If you're drafted, then the shadow that glosses over your rights becomes darker. You have less rights. You've got to serve your country. We are in a state of emergency. The penumbra changes.
And with regard to the pursuit of happiness,
That's an interesting
how do you
one.
see that?
That's an interesting one. What is the pursuit of happiness? People want everything, and they think that's happiness. But then we're finding that is happiness materialistic or is it not?
No.
But we live in a capitalistic society where that's built upon obtaining things. What does your money buy you, right?
Yeah.
And now we're at an interesting time where people are realizing I can buy 1 million things on Amazon for $10.99 and I'm not happy.
True.
Okay? I don't know. I don't know what happiness means.
So I think that's how the pursuit of happiness, I think that's how that ties into pursuing the education of your choice, pursuing the occupation and the familial relationship. So,
but you bring up saying education is so important because
yeah,
occupation doesn't equal happiness. You can make as much money in the world and not be happy. We've just talked about materialism, but education could lead to ultimately finding happiness, right? So, or at least knowing what happiness is or where to find it or how to find it. Maybe it's a sidebar, but it's interesting.
Well, don't they say the joy is in the journey?
It's more complicated the older you are, and I think that's a part of the journey.
The human condition.
The human condition.
As it applies to liberty.
The human condition. I think liberty does encompass all of that. That's why there's a penumbra. That's why there's fluidity.
The Constitution's amendments create zones of privacy. And the right to privacy is implied right or liberty found in Supreme Court case law. And I think that ties into you have privacy rights, but then it's like there's the scope of privacy. What is a reasonable expectation of privacy? So if I take something and I throw it in the trash can, and it's a public trash can, that I have no expectation of privacy in what I've just discarded, right? On the other hand, we had the Katz case, Katz v. U.S. in 1967. The guy was in a phone booth having what he thought was a private conversation, and the government had wiretapped the inside of the phone booth, and so that was said to have violated his right to privacy because they said, do you have a reasonable expectation of privacy in that conversation inside the phone booth? And the court said yes. But you're saying that they overturned abortion case as far as saying that, because I didn't look at the grounds of it, so you're saying the grounds are that they do not have a privacy right?
From my understanding, briefly going over it, is that the right to abortion is rooted, and it was recognized as an individual right, but also it was rooted from the right to privacy.
But there was always a distinction between post-viability and pre-viability.
There was. At the very least, the court did find that there was a distinct right a woman had, at least at a certain time, to pursue an abortion.
The Bergefell case was decided on 14th Amendment due process grounds as well as the Equal Protection Clause. Mm-hmm. So it was not, that was not
contraceptive. The right to use contraceptives.
Right.
That's
within a marriage.
Privacy. I hope I'm not getting confused there. But the big takeaway is that the court ruled that there was a specific right a woman had to abortion in Roe v. Wade, that the Supreme Court, in overturning it, stated there's no definitive
blanket
right to that. And it, once again, it goes back to fluidity. It changes.
Thanks, Dee. This has been the Scope of Liberty episode here on People Acting Like Lawyers and Mostly Malarkey. We thank you for joining us today, and we'll be bringing you more content soon. That's a wrap.